Hello, welcome back. Again, I am Stephen Lieberman. I'm going to be your guide as we go through this four-part course on the history and the modern-day implications of the Second Amendment. Now, in this video, we're going to be talking about the historical context of the Second Amendment. With all things, we need to understand its history. What's interesting with the Second Amendment, as far as a historical analysis is concerned, is that we don't actually start at the ratification of the Constitution in 1791. Actually, we have to go back further than that. In fact, we have to leave the continent altogether. We have to start in England. Specifically, we have to start with the English Bill of Rights in 1689. We'll be discussing that in a second, but I want you guys to understand something. I want to sidebar for a second. You need to be aware that at the time of the ratification, the United States was a gun culture. Now, you're going to hear me make reference to gun culture quite frequently throughout these videos, and I want to sort of define the concept right at the very beginning. In order for something to be a culture, it has to have, in my opinion, two very specific qualities. First and foremost, there needs to be a shared language among the participants within that culture. In addition, there needs to be a reasonable belief that an existential threat exists to that culture. Let's give you an example. Somebody who is a golfer, golfs on a regular basis. There is, without question, a shared language that exists amongst all golfers. Everything from the way that they refer to their clubs to the way a fairway lies or the way a green breaks. There is a shared language. There's a common nomenclature, so to speak. And yet, in the golfing community, there is not a perceived existential threat to the community. There aren't thousands of protesters screaming that all golf courses need to be banned. Quite the contrary. While individual courses may, from time to time, end up getting sold off, there is nobody that is currently playing golf that is fearful that, say, 5 years from now, it will be impossible to play golf. As a result, golfing does not actually have a culture attached to it. It's got, effectively, a group of people that simply happen to enjoy the same activity. However, for something to be an actual culture, you do need to have that shared language, and it doesn't necessarily need to be around an activity. It could be tribal, right? It could be an individual city-state. It could be an ethnic group of people. So you have this shared language, but you also have a belief, at least reasonable to the people within the culture, that there is an existential threat, that there are barbarians at the gate, that but for the defense of the culture itself is going to be wiped out. This becomes an animating principle. Now, the gun culture modernly certainly exists. I mean, there is absolutely a shared language. We have very specific nomenclature. And we do tend to have a lot of variance in the way we actually talk about certain aspects of the Second Amendment or the gun culture community. But there is, in fact, a belief, and it is absolutely reasonable, that there is an existential threat to the culture. Anti-gun politicians, anti-gun jurists, anti-gun political activists would seek to completely remove or eliminate the Second Amendment and someone's ability to keep and bear arms. This is more than simply reasonable. This is empirical. We can actually see that there are, in fact, people that would like to dismantle and completely eradicate the Second Amendment. So, modernly, we have both components. Now, interestingly enough, at the time of the ratification of the Constitution in 1791, while I say there was a gun culture, it really hadn't manifested yet into an existential threat. There wasn't necessarily a pervasive belief that our ability to bear arms was going to be restricted at all. And up until 1791, people, generally speaking, didn't really think of being involved in a gun culture it was just simply part of everyday life. Everybody owned guns. Everybody was familiar with firearms. It wasn't until just before the Revolutionary War that the British effectively engaged in an act of gun control. They tried to take our powder and our shot at the Concord Armory. We stopped them at Lexington Green. And as a result, we ended up having a revolution, which ultimately brought about our country. One could legitimately state that the United States was found on an objection to gun control. The British were trying to restrict our access to our powder and our shot, and we ended up starting a war as a result. So at that point, a gun culture began to emerge. There was, in fact, a common language that existed among all people that bore arms, and there was now this existential threat. And going back, as I mentioned earlier, back to England in 1689 with the English Bill of Rights, this was effectively the people's attempt to fashion something which would be somewhat similar to our Constitution. Didn't have the same rights and protections that our Constitution does, but it was a starting point. It was a far cry improved over the original Magna Carta. Now, in the English Bill of Rights, there is something that somewhat resembles a Second Amendment. People had the right to bear arms. Now, it was limited into certain aspects. Specifically, it was limited as to who actually enjoyed this right. Specifically, they sought to prevent Catholics from being able to bear arms. This really only applied to Protestants. This was the beginning of a division that would start to manifest, where in our present day, we look at the Second Amendment and we say, well, who does it actually apply to? After all, at the very beginning of the Constitution, we talk about we the people. And yet, who are the people? And that is something that we will be discussing in a subsequent lecture. But suffice to say that going back to the original English Bill of Rights, we see the foundation, the kernel, the thing that would manifest among the minds of the framers during the time of the ratification. There was also something called the Treaty of Northampton that also took place in England. The Treaty of Northampton, that was a specific attempt to disarm certain political enemies of the crown. Interestingly enough, when we parse out the language of the Treaty of Northampton, something that we will also see become more and more prevalent in modern American jurisprudence, we see that the bearing of arms as a means of terrorizing the population is something that should be considered illegal. Simply bearing arms for personal protection, that is absolutely foundationally different. So these two documents sort of make their way into the American mind at the time of the Revolution. And as the Revolution concludes and we adopt the Articles of Confederation, the sort of the predecessor to our Constitution, we decide that it's critically important that as we develop this Constitution, we enshrine certain rights. Now, as I mentioned in our previous sort of introductory video, the rights that became enshrined were not granted by the subsequent document, the Constitution. Rather, those rights pre-existed the Constitution from the very beginning. It's just that the framers recognized them, placed them in the Constitution under what we now call the Bill of Rights, effectively mandating that government, regardless of who is elected, is prohibited from engaging in any conduct that would potentially affect these rights, or, as it relates to the Second Amendment, any sort of conduct that would infringe on people's rights. And again, as we get into the modern interpretations of the Second Amendment in subsequent lectures, we'll flesh that out to a great deal more. But suffice to say, going back to 1791, we are, at this point, a legitimate gun culture. We also have very, very different impressions and interpretations as to what freedom means. And in fact, this is something that began hotly being debated during the Revolutionary War itself, in the years leading up to the Revolutionary War. Traditionally, when we think of the exercise of fundamental rights, and the Second Amendment is, without question, a fundamental right, and that will be mandated by a case that we'll be discussing later on called Heller versus the District of Columbia, as well as McDonald versus Chicago. So we know that the Second Amendment is, in fact, a specifically enumerated right. And a specifically enumerated right is designed to help maximize individual freedom. And yet, what is freedom? What is it that we mean when we talk about being free? And surprisingly, there wasn't a tremendous amount of consensus at the time of the ratification as to what freedom actually meant. If you were to talk to somebody from Massachusetts, freedom meant living in a society that was fairly heavily regulated so that you could reasonably predict the behavior of your neighbors. And because you could predict the behavior of your neighbors, because you were living within this heavily regulated society, you would now have the opportunity to engage in commerce and make a fair amount of money. After all, if your neighbors are going to be constrained by various rules, then you can profitize on those rules, right? You can make money based on this. Conversely, if you were living in the South, it was completely different. If you were living in the South, there was a good chance that you were living in a fairly rural area, and you largely made your money on the export of agricultural goods. Well, you wanted to have the least amount of government control, the least amount of regulations within your society, primarily not because you were looking to take advantage over your neighbors. Rather, you were looking to maximize your own individual initiative so that you could hopefully make more money that way. So money seemed to be the root of both of these things. Now compare that to somebody like George Washington, right? So George Washington and people like George Washington, already established, very wealthy farmers, they didn't look at freedom as being the absence of regulations, nor did they look at freedom as being some sort of anachronistic, or not necessarily anachronistic, but anarchy-based system where individuals were free to do essentially whatever they wanted. Rather, they looked at freedom as being an economic set of circumstances that would allow an individual to become learned, would allow an individual to become spiritually enlightened, that would allow an individual the opportunity to explore the humanities so that they could be well learned, understood, and, by definition, improve society as a whole. Being free, in the minds of somebody like George Washington, was actually a huge burden. Now, contrast this to the more modern libertarian ideals of, say, the mountain men, who went to the West. They were essentially leaving society altogether. Those people were true anarchists in many respects. They were looking to be free not only from the economic and regulatory environments of the established cities and colonies of the American frontier. Rather, they were looking for cultural freedom as well. And sometimes they would adopt the social mores of Native American tribes. Other times they essentially would live as hermits. But they were effectively finding freedom in taking themselves out of society. So you've got all these different concepts of freedom, and then we've got this thing called a gun, right? And the idea that a free person could be in possession of a gun isn't necessarily just a very flat analysis. Different things mean different things to different people, right? So we need to actually understand what it was the framers were thinking when they first came up with the idea of codifying the Second Amendment. I mean, why even have this thing to begin with? Well, there were actually a number of reasons, and some of them actually appear to be somewhat at odds with one another. First and foremost, as you can see I've got written up on my board here, we have the core purpose Individual self-defense. Now, individual self-defense, that is not a term that the framers would have used in 1791. They actually would have referred to resistance to tyranny. So the idea that you would thwart someone's actions that were seeking to do your harm was actually a fairly broad-based concept. That could be at the hands of a robber on the trail. That could be at the hands of a neighbor who was trying to steal your property, or that could be at the hands of a tyrannical government, or even an occupying military force. We would use the term resistance to tyranny as essentially meaning what modernly we would call self-defense. So self-defense, or resistance to tyranny, was certainly at the top of their list. But it wasn't the only reason that the framers ratified the Second Amendment. There was also a concept called collective self-defense. So this is something that modernly, really after World War II, has majorly played out. There was an argument promulgated after World War II that the Second Amendment does not apply to people. The argument that was proffered was that the Second Amendment only applied to states. And if you look at the language of the Second Amendment, there is a legitimate, colorable argument here, right? I mean, after all, the prefatory clause, the beginning of the Second Amendment says, a well-regulated militia being necessary to the security of a free state. Okay, so this, with some people's minds, would suggest that the Second Amendment is designed for the security of a free state. Therefore, this right attaches to the state, and it allows the state to assemble a militia or have a National Guard or something like that. Forget the fact that the National Guard did not exist at the time of the ratification. The concept of having a militia certainly did. So we have these two sort of competing concepts here. So the Second Amendment is an individual right that would allow you to resist tyranny, to be able to have a form of self-defense. But it also is a collective right that as you are armed and as you are protecting yourself, you may be called upon to join fellow patriots to protect your community from an occupying military force or a tyrannical government or the town bully or whatever it happens to be. So it may not necessarily correlate to the modern argument that it's either or, that the Second Amendment was only for individual liberty or only for collective rights. It might be better to argue, and this is frankly the way that I do, that it's both an individual right and a collective right. Now, in Heller versus the District of Columbia, which we will be talking about later on, that absolutely mandates that the Second Amendment is, in fact, an individual right. And I don't want you to kind of go off thinking that it's not. Okay, so the framers clearly identified an individual right. They clearly identified a collective, perhaps responsibility might be a good way of describing it. They also saw that the mere possession of arms by a populace served as a deterrent to tyranny. So one of the most fascinating things that I got to witness, my daughter, Cheney, is a graduate from the United States Military Academy at West Point. And while she was at West Point, we visited her quite often. For those of you who have never been, West Point is on the Hudson River, and it's about an hour north of Manhattan. Well, West Point was a strategic location during the Revolutionary War, specifically because of its geography and its unique ability to disrupt the trafficking of British goods from Manhattan up into Canada. So in order to achieve this, George Washington actually commissioned to have a giant chain taken from West Point all the way across the Hudson River to the other side of the Hudson to a place called Cold Springs. Now, this chain, which was fairly robust, and you can still see links from the chain at West Point itself, this was designed to prevent British sailing ships from being able to pass through on their way up to the Hudson. Now, while simply having a chain might be more or less of an annoyance to the British ships, what really caused them not to go was the fact that once they were stopped, all of the cannons that George Washington had mounted up on the turrets of West Point would rain down cannonballs on the ships, preventing them from being able to survive the experience. As a result of the deterrent factor of having these weapons and having them aimed at the Hudson River, there were no British ships that sailed north. Effectively, the deterrent factor was able to keep the British from, continuing their trade with northern New York as well as in Canada. Modernly, we saw the same thing when we had our Cold War against the Soviet Union. There was a concept called mutually assured destruction, effectively saying if you launch a nuclear strike against the United States will fire a retaliatory strike against you. The net result is that we're going to wipe out all humanity across the planet. At least that was the belief system. This deterrence, this threat of reprisal, effectively was strong enough to keep both nations from going to war. So the framers were well aware of the deterrent value of having weapons. If you have an armed populace, then a foreign invader may be more hesitant to actually cross the ocean and try to attack us. And lastly, and it's funny, I hear people say, and I see internet memes that say to the same type of effect, that the Second Amendment was not to protect hunting. And yet the Second Amendment actually was to protect hunting. Hunting and survival was an absolutely integral part of the colonial experience. People that lived in rural parts of America, and most of America at the time of the colonial expansion, as well as into the actual establishment of the United States, was a very rural type environment. There were cities, of course, but a lot of people, in fact, the majority of people, frankly, lived on the frontier. They lived in farms. They lived in rural communities. And hunting was essential to someone's ability to survive. So, yeah, the Second Amendment, not only was it there for resistance to tyranny, for collective responsibilities, for a deterrence factor against a foreign invader, but it was also to shoot deer. It was also to make sure that someone had the ability to survive in what was essentially a hostile sort of rural environment in America. Now, when the delegates at the Constitutional Convention, when they arrived, there was a debate as to whether or not they should even have a Bill of Rights. After all, if you list a right, that might presuppose that other rights didn't make the cut, and therefore they're not rights. And when it came to weapons, this was a big deal because what are weapons going to look like, say, 200 years from now? They had already seen weapons go through fairly dramatic changes over the last 200 years. And in fact, if you looked back on antiquity, weapons had changed massively since the time of the Greeks and the time of the Romans. So our framers were well aware of the fact that technology, that metallurgy, that the type of weapons that we would be using would fundamentally shift. They also knew that the concept of a firearm, while prevalent clearly at the time of the ratification, wasn't the only type of weapon that somebody could be bearing. More importantly, the types of weapons that would exist, say, 200 years in the future were completely unfathomable to the delegates of the Constitutional Convention. And they were not making a constitution just for their generation. They were making a constitution for the future. They were making the Constitution for their posterity. As a result, in the Second Amendment, you will not see the term firearm or gun or anything of such nature. It does refer to arms, But those arms could be edged weapons, they could be guns, they could be, as we will soon see, stun guns, they could be leather-cased, billy clubs. They could be weapons like photon torpedoes or laser guns, things that we have not even yet envisioned. Ultimately speaking, the Second Amendment, when it was finally ratified, was done so to prevent the government from making laws that would infringe on people's rights. Now, interestingly enough, and this will become very, very important, there were some laws at the time of the ratification that restricted people who could use weapons, as well as the types of weapons people could use. Additionally, there were what could best be described as safety laws. Now, this will become important because of a future case that we'll be discussing called New York State Rifle and Pistol Association v. Bruin. That case instructs us that for a law, a modern law, one today, to be constitutionally consistent, we need to look back at the history, text, and regulatory traditions that existed in 1791. Yes, there were certain forms of gun control in 1791. In urban areas, there were restrictions on how much powder you could have for your rifle or your pistol. More importantly, there were certain mandates that powder be stored at certain locations. Yeah, you might be able to have a small amount of powder in your home, but the bulk of your powder would have to be stored in an armory. Well, this was designed specifically because they didn't want large-scale fires ripping through entire neighborhoods because somebody lit a match next to somebody who happened to have a lot of gunpowder or something along those lines. So there were some levels of restrictions. And like our brothers across and sisters across the pond, just like we had in 1689 with the English Bill of Rights, we had our own racial history here in the United States. We didn't feel very comfortable allowing certain people to bear arms at the time of the ratification. Slaves were right up at the top of the list. Even though slaves, by definition, are human beings, and today, of course, we would find slavery to be absolutely abhorrent and a stain, frankly, on our national story, slaves were not considered people and therefore were not allowed to bear arms. Now, this makes somewhat sense. If you were a slave owner, you would probably be not overly thrilled about the possibility of a slave retaliating against you and having the tools necessary to be able to defend themselves and to be able to potentially dispatch you. After all, if you're using weapons possession as a form of deterrent, you may be less inclined as a slave owner to engage in abusive conduct to your slaves if you know that the slaves are armed or at the very least have access to weapons. So they were prevented from having guns. Native Americans were prevented from having guns. And one of the reasons for that was, quite honestly, because we were afraid that Native Americans would attack us. And we had some empirical evidence to suggest that that actually would happen. So there was a bar on Native Americans being able to possess firearms, even though the framers would argue that these rights came from the Creator, that these rights came from God and were simply codified in the Bill of Rights. They would effectively make the argument that God had theologically made the decision that the rights that he granted to his creation, man, would not extend to all men. And this was theologically incredibly problematic and ultimately would arise to become part of the abolition movement because there was philosophical inconsistency here. Now, all that being said, this sort of beginning, so to speak, it wasn't fleshed out. It wasn't clear. There wasn't a tremendous amount of legal data that we can look to say that a modern restriction on firearms was consistent to a colonial or to a just before, a pre-ratification or just an immediate post-ratification restriction on the use of firearms. But there were certain laws that did exist that prevented people from being able to completely exercise their right to keep and bear arms. This will come into play more so in our next lecture as we move forward, not only into our constitutional history, but a deeper understanding of the philosophical underpinnings of the Second Amendment and Second Amendment jurisprudence. Thank you.